This is the order that started the clock. On Friday, March 7th, 2026, at approximately 3:42 p.m. Eastern Standard Time, Judge Catherine Whitmore of the New York State Supreme Court issued a 37-page order that fundamentally altered the timeline of Donald Trump's legal crisis from indefinite to finite. The order, which was delivered from the bench and entered into the court record within minutes, establishes a series of non-negotiable deadlines that create what legal experts are calling a judicial countdown to total asset liquidation. The critical provision appears on page 23 of the order. The defendant is hereby ordered to produce complete and verified financial disclosures, including all domestic and international assets, all sources of income, all debt obligations, and all transfers of property or funds exceeding $10,000 made within the past 24 months, no later than 5 p.m. Eastern Time on Friday, March 21st, 2026. Failure to comply fully with this order by the specified deadline will result in the immediate appointment of a special master with plenary authority to assume control of all defendants' assets, the issuance of contempt sanctions in the amount of $100,000 per day until compliance is achieved, and the referral of the defendant to state and federal prosecutors for criminal contempt charges. According to 3 attorneys who were present in the courtroom when the order was read, the reaction from Trump's legal team was visible shock, followed by immediate requests for clarification about whether the deadline could be extended. Judge Whitmore denied all extension requests before they were fully articulated, stating that the defendant has had 18 months to comply with discovery obligations and that further delay will not be tolerated under any circumstances. The 14-day countdown that began on March 7th represents the final window in which Donald Trump retains any control over his financial affairs. After March 21st, if the disclosures are not complete and verified, control transfers permanently to a court-appointed special master. The legal countdown has begun, and this time there is no mechanism to stop the clock. To understand why this court move is critical and why it initiates an irreversible countdown, it is necessary to examine what happens when a defendant in civil litigation refuses to comply with court-ordered discovery. Discovery is the process by which parties to a lawsuit obtain evidence from each other. In financial fraud cases, discovery typically includes demands for bank statements, tax returns, property records, corporate documents, and sworn testimony about assets and liabilities. Courts have broad authority to compel discovery, and when defendants refuse to comply, courts can impose escalating sanctions. The sanctions can include monetary fines, adverse inference instructions that tell juries to assume the defendant is hiding unfavorable information, and ultimately the appointment of a special master or receiver who takes control of the defendant's property to ensure compliance. Judge Whitmore's order represents the final step before the most severe sanctions are imposed. Trump has 14 days to produce complete financial disclosures that he has been resisting for 18 months. If he complies, the disclosures will reveal the true extent of his assets and liabilities, which will guide the enforcement process, but will at least allow Trump to maintain some involvement in decisions about which assets to liquidate and in what order. If he fails to comply, he loses all control. A special master appointed by the court will have authority to access every bank account, to examine every property record, to interview every business associate, and to make unilateral decisions about asset liquidation without Trump's input or consent. The specific requirements of the disclosure order are detailed on pages 8 through 17 of Judge Whitmore's ruling and are far more comprehensive than standard financial discovery in typical civil cases. The order requires Trump to produce complete documentation for every bank account he owns or controls, including accounts held in the names of trusts, corporations, or other entities where Trump is a beneficial owner. The order requires documentation of all real property interests, including properties owned in fee simple, properties held through ground leases, properties owned through partnership interests, and properties in which Trump holds any equitable interest regardless of how legal title is held. The order requires disclosure of all personal property with a value exceeding $25,000, including vehicles, aircraft, artwork, jewelry, and collectibles. The order requires disclosure of all intellectual property interests, including trademarks, licensing agreements, and media rights. The order requires disclosure of all debts and obligations, including mortgages, personal loans, business loans, guarantees provided to third parties, and contingent liabilities arising from pending litigation. The order requires a detailed accounting of all property or fund transfers exceeding $10,000 made within the past 24 months, including the date of transfer, the recipient, the stated purpose, and the consideration received. The order requires that all disclosures be made under oath with verification that the information is complete and accurate to the best of the defendant's knowledge. Here is the critical structural problem that makes compliance with the disclosure order extraordinarily difficult for Trump, even if he decides to cooperate fully. Trump's business affairs have been deliberately structured over decades to maximize opacity and to make it difficult for creditors, regulators, or investigators to determine what he actually owns and what he actually owes. Properties are held through layered corporate structures where limited liability companies own partnership interests in entities that hold title to real estate. Bank accounts are spread across dozens of institutions, with some held in personal names, some held in corporate names, and some held in trust names. Assets have been transferred between entities in transactions that were characterized at the time as loans or sales, but that may have been disguised gifts or fraudulent conveyances designed to shield assets from creditors. Reconstructing this web of transactions to produce complete and accurate disclosures would require months of work by forensic accountants with full cooperation from Trump and access to all records. Trump has 14 days. The timeline is mathematically insufficient to produce the level of detail the order requires unless Trump has already prepared comprehensive financial records in anticipation of this demand. According to sources familiar with Trump's business record-keeping practices, no such comprehensive records exist. The Trump Organization has historically operated with minimal documentation, with decisions made by Trump personally based on instinct rather than formal analysis, and with record retention policies that were inconsistent at best. The impossibility of full compliance within 14 days creates a strategic dilemma that has paralyzed Trump's legal team. If Trump attempts to comply but produces incomplete or inaccurate disclosures, he risks contempt findings and criminal referrals for providing false information under oath. If Trump refuses to comply or produces minimal disclosures, the special master is appointed immediately, and Trump loses all control. If Trump requests an extension, he has already been told that no extension will be granted. The least bad option may be to produce partial disclosures accompanied by a sworn statement that complete disclosures cannot be prepared within 14 days due to the complexity of the financial affairs and the limited time provided, while requesting additional time and offering to cooperate with court-appointed accountants who can assist in compiling complete information. This approach might avoid contempt findings while also avoiding the immediate appointment of a special master with plenary authority. Trump's attorneys are reportedly debating whether to recommend this approach, but the strategy requires Trump to admit under oath that he cannot provide complete financial information about his own affairs, which is an admission that contradicts his long-standing claims of being a brilliant businessman with detailed knowledge of every aspect of his empire. The special master provision in Judge Whitmore's order is particularly devastating because of the scope of authority that would be granted. The order specifies that upon failure to comply with disclosure requirements, the court will appoint a special master with plenary authority over all assets. Plenary authority means complete and unlimited authority. The special master would have the power to access all bank accounts and to freeze or transfer funds as necessary to satisfy judgments. The special master would have authority to take possession of all real property and to make decisions about whether to sell properties, lease properties, or continue operations. The special master would have authority to examine all corporate records and to interview all employees, vendors, and business associates. The special master would have authority to void any transactions made within the past 24 months that appear designed to defraud creditors or to conceal assets. The special master would report directly to the court and would be required to act in the best interests of creditors rather than in Trump's interests. The appointment of a special master with this scope of authority would effectively end Trump's business career. He would become a bystander watching someone else dismantle his life's work. The contempt sanctions specified in the order create an independent financial pressure that accelerates Trump's asset depletion. $100,000 per day in contempt fines beginning on March 22nd. If compliance is not achieved, means $3 million in additional liability within the first month. The fines accumulate daily and are not subject to appeal or stay pending appeal. They must be paid as they accrue. If Trump fails to pay the daily contempt fines, the court can issue additional enforcement orders, including wage garnishment and asset seizure. The contempt fines create a separate stream of liability that exists in addition to the underlying judgments Trump already faces. The strategic purpose of imposing daily fines rather than a single lump sum contempt penalty is to create continuing pressure that increases every day Trump remains in non-compliance. The psychological effect of watching $100,000 per day being added to his debts creates urgency that might force Trump to cooperate even if his instinct is to resist. The criminal contempt referral provision represents the most serious personal threat to Trump in the disclosure order. Civil contempt involves sanctions designed to compel compliance with court orders. Criminal contempt involves prosecution for willful violation of court orders with potential penalties, including fines and incarceration. If Judge Whitmore refers Trump to prosecutors for criminal contempt, the referral creates a new criminal investigation separate from the existing federal prosecutions Trump is facing. Criminal contempt does not require proof of harm or damage. It only requires proof that the defendant willfully violated a clear court order. If Trump received the disclosure order, understood its requirements, had the ability to comply, and chose not to comply, those elements establish criminal contempt. A conviction for criminal contempt of court can result in up to 6 months in jail per count. If Trump is found to have violated multiple provisions of the disclosure order, multiple contempt counts could be charged. The threat of incarceration for contempt is designed to make clear to Trump that defying the court's disclosure order carries personal consequences beyond financial penalties. But here is the catch, and this is what makes the countdown inexorable regardless of Trump's choices. Even if Trump provides complete and verified financial disclosures by March 21st, the information contained in those disclosures will be used immediately to accelerate enforcement actions that Trump has been trying to delay. The disclosures will identify bank accounts that can be levied, properties that can be seized, and transfers that can be voided as fraudulent conveyances. Judgment creditors who have been frustrated by their inability to locate Trump's assets will suddenly have a court-ordered roadmap showing exactly what exists and where it is located. The Marshal Service and other enforcement agencies will use the disclosures to update their asset inventories and to execute seizure orders within days of receiving the information. Compliance with the disclosure order gives enforcement agencies the tools they need to complete asset liquidation far more quickly than would otherwise be possible. Non-compliance results in appointment of a special master who will conduct the same investigation with even more authority. Either path leads to total asset liquidation. The only variable is whether Trump retains some minimal involvement in the process or loses control entirely. The 14-day timeline is particularly significant because it overlaps with several other critical deadlines in Trump's various legal proceedings. On March 18th, Trump faces a deadline to file opposition papers in a federal appeal challenging the denial of his motion to dismiss the January 6th criminal case. On March 20th, Trump faces a trial-setting conference in the federal financial crimes case where the judge will establish a trial date and pretrial motion deadlines. On March 24th, Trump faces a deadline to post a supersedeas bond of $135 million in the E. Jean Carroll defamation case or face immediate execution of that judgment. The convergence of these deadlines creates a resource crisis for Trump's legal team. The attorneys working on the New York disclosure compliance have limited time to also prepare appellate briefs and trial strategy. The financial resources needed to post the Carroll bond are being depleted by legal fees and contempt fines. The psychological stress of managing multiple simultaneous crises is evident in the quality of Trump's legal filings, which have become increasingly erratic and poorly reasoned over the past month. The political implications of the disclosure deadline extend beyond Trump's personal legal situation and affect the 2026 midterm elections that are now 8 months away. Republican candidates in competitive districts are facing increasing pressure from donors and party leadership to distance themselves from Trump. The disclosure deadline creates a specific date, March 21st, when the public will either learn comprehensive details about Trump's true financial condition through court filings or will learn that Trump defied a court order and lost control of his assets to a special master. Either outcome is politically toxic for Republicans running in swing districts. If the disclosures reveal that Trump's actual net worth is a fraction of what he has claimed, it confirms that his billionaire persona was fraudulent and undermines his credibility with voters who supported him based on his business success narrative. If Trump defies the court and loses control to a special master, it confirms that he is unmanageable and unfit for leadership. Republican strategists are advising candidates to have messaging prepared for March 21st that distances them from Trump regardless of which outcome occurs. The countdown is political as much as legal. The international dimension of the disclosure requirement creates potential diplomatic complications that the State Department is monitoring closely. Trump has business relationships and alleged financial interests in multiple foreign countries. If the court-ordered disclosures reveal financial ties to foreign governments or foreign nationals that were not previously disclosed, those revelations could violate the Foreign Corrupt Practices Act, could create counterintelligence concerns, or could provide leverage for foreign governments seeking to influence American policy. The disclosure order requires Trump to reveal all assets regardless of location, which means any offshore accounts or foreign holdings must be disclosed. Foreign governments that host Trump properties or that have nationals who have invested in Trump ventures are closely watching to see whether those relationships are revealed in the disclosures. Some foreign governments have quietly communicated to the State Department that they would view disclosure of certain business relationships as violations of confidentiality agreements or as harmful to bilateral relations. The State Department has no authority to prevent Trump from complying with a court order, but the diplomatic complications created by the disclosures could affect America's relationships with key allies and partners. The legal precedent being established through Judge Whitmore's disclosure order will affect how courts handle recalcitrant defendants in complex financial litigation for decades. Defendants in civil cases have always had discovery obligations, but the comprehensiveness and specificity of Judge Whitmore's order, combined with the severity of sanctions for noncompliance, represents an escalation in judicial enforcement of discovery obligations. Defense attorneys are analyzing the order to determine whether its requirements exceed constitutional limits on compelled disclosure. The Fifth Amendment protects against self-incrimination, but that protection does not extend to disclosure of assets in civil cases unless the disclosure would provide evidence of criminal activity. Trump's attorneys may argue that requiring disclosure of all property transfers in the past 24 months would reveal fraudulent conveyances that could be used as evidence in criminal prosecutions, and that therefore the Fifth Amendment privilege applies. If that argument is accepted, Trump could refuse to disclose transfers while claiming constitutional protection. If the argument is rejected, the precedent would establish that civil defendants cannot use Fifth Amendment privileges to avoid asset disclosure even when criminal exposure exists. The strategic calculation that Trump must make by March 21st involves weighing the consequences of disclosure against the consequences of defiance. Disclosure reveals information that will be used against him in enforcement actions and potentially in criminal prosecutions. Disclosure confirms his true financial condition, which is likely far worse than he has publicly claimed. Disclosure provides a roadmap for creditors to seize every asset he owns. But defiance results in immediate loss of control to a special master, daily fines of $100,000, and criminal contempt referrals. The calculation is complicated by Trump's psychological inability to admit weakness or to provide information that contradicts his public claims of wealth and success. Providing verified disclosures that show his actual net worth is a fraction of his claimed net worth requires Trump to sign documents under oath admitting that his billionaire persona was exaggerated or false. For someone with Trump's narcissistic personality structure, that admission may be psychologically impossible, even if it is legally optimal. The worst-case scenario timeline that begins on March 21st assumes non-compliance or substantially incomplete compliance with the disclosure order. On March 22nd, Judge Whitmore issues an order appointing a special master and imposing daily contempt fines. The special master, likely a retired judge or an experienced bankruptcy trustee, begins immediately to exercise plenary authority over Trump's assets. Within 48 hours, the special master freezes all bank accounts and issues notices to all financial institutions holding Trump accounts, directing them to accept no instructions except from the special master. Within 1 week, the special master takes physical possession of property records and corporate documents for all Trump Organization entities. Within 2 weeks, the special master completes an initial asset inventory and begins making decisions about which properties to liquidate first. Within 30 days, the special master authorizes the sale of multiple properties to begin satisfying judgments. Within 60 days, the first sales close and proceeds flow to creditors. Within 90 days, the special master concludes that Trump's remaining assets are insufficient to satisfy all judgments and files a report with the court, documenting total asset depletion and recommending that Trump be declared judgment-proof, meaning he has no assets available to satisfy creditors. The entire process from March 21st to complete liquidation takes approximately 90 days. By mid-June 2026, Trump owns nothing and owes everything. The alternative scenario, where Trump provides complete and verified disclosures by March 21st, delays the appointment of a special master, but does not avoid asset liquidation. The disclosures provide enforcement agencies and judgment creditors with detailed information about assets that can be seized. Within days of receiving the disclosures, multiple creditors file new enforcement motions seeking to levy specific accounts or seize specific properties identified in the disclosures. The court grants these motions because Trump has now admitted under oath that the assets exist and has provided documentation of their location and value. The enforcement actions proceed in a coordinated manner guided by the disclosure documents. The timeline is similar to the special master scenario, with complete liquidation occurring within 90 to 120 days. But Trump retains some ability to negotiate which assets are sold first and to argue about valuations and priorities. The outcome is the same, total asset loss, but the path is slightly less humiliating because Trump participates in the process rather than watching a special master execute it without his input. The psychological countdown that parallels the legal countdown is evident in Trump's behavior over the past week, according to sources who have interacted with him. Trump is reportedly obsessed with the March 21st deadline, asking advisors repeatedly whether there is any way to extend it, whether there is any legal argument that could void the order, whether he could claim that producing the disclosures would violate his Fifth Amendment rights. The advisors have told him repeatedly that no extensions will be granted, that the order is legally sound, and that Fifth Amendment arguments will not work in this context. Trump is struggling to accept that he is out of options and that the countdown will conclude in one of two ways. Either he discloses everything and faces the consequences, or he refuses to disclose and faces worse consequences. The internal White House mood is described as increasingly grim. Cabinet members are reportedly discussing whether Trump can effectively govern while consumed by the disclosure crisis. The answer appears to be no. Trump is missing meetings, is skipping intelligence briefings, and is spending hours each day with lawyers discussing the disclosure deadline rather than focusing on presidential responsibilities. The historical significance of a sitting president being subject to a judicial countdown to asset liquidation cannot be overstated. No president in American history has faced a court order requiring comprehensive financial disclosure under threat of contempt and asset seizure while in office. The situation creates constitutional questions that have no clear answers. Can the president perform his duties effectively while complying with court orders that require him to spend substantial time and resources documenting his personal finances? Can the judiciary impose deadlines on a sitting president that create time pressures that interfere with executive responsibilities? The Constitution does not address these questions because the framers did not anticipate a president who would enter office with massive debts and complex business entanglements that would lead to civil litigation requiring intensive judicial oversight. The precedent being established will shape how future presidential conflicts between judicial obligations and executive responsibilities are resolved. The countdown is also exposing the inadequacy of existing ethics and disclosure requirements for presidential candidates. Federal law requires presidential candidates to file financial disclosure forms showing their assets, income, and liabilities. But the disclosure forms are designed for public officials whose finances are relatively straightforward. The forms are not designed for real estate developers with hundreds of corporate entities and complex international holdings. Trump filed the required disclosure forms when he ran for president, but those forms provided only high-level summaries and allowed for broad ranges in asset valuations. The forms were never intended to provide the level of detail that Judge Whitmore's order now requires. The disconnect between the minimal disclosure required to run for president and the comprehensive disclosure now being ordered by a court reveals that the presidential ethics framework is insufficient to address candidates who come from complex business backgrounds. Legislative proposals are already being drafted to require presidential candidates to provide detailed financial disclosures comparable to what Judge Whitmore has ordered, but those proposals will not become law in time to affect Trump's situation. The financial markets are beginning to price in the probability that Trump will lose all assets by summer 2026. Commercial mortgage-backed securities that include Trump properties as collateral have declined in value by 8 to 12% over the past 2 weeks as investors anticipate that forced sales will reduce recovery values for lenders. Real estate investment trusts that hold luxury properties in markets where Trump properties are located are experiencing price declines based on concerns that Trump property liquidations will depress comparable sale values. The financial contagion from Trump's legal countdown is measurable in market prices even before the March 21st deadline arrives. Bond traders and equity analysts are modeling scenarios based on whether Trump complies or defies the disclosure order and what enforcement actions result. The consensus view is that regardless of which path Trump chooses, the outcome will be significant wealth destruction that will affect not just Trump, but also lenders, investors, and other market participants with exposure to luxury real estate markets. As we approach the midpoint of March 2026, the legal countdown initiated by Judge Whitmore's order on March 7th is proceeding inexorably toward the March 21st deadline. 14 days have become 11 days. Soon they will be 7, then 3, then 1. On March 21st at 5 p.m. Eastern Time, one of two things will happen. Either Donald Trump will produce complete and verified financial disclosures that reveal the true extent of his assets and liabilities and that provide a roadmap for creditors to seize everything he owns, or he will fail to produce complete disclosures and will immediately lose control of his assets to a court-appointed special master while facing daily fines of $100,000 and criminal contempt referrals. The choice Trump makes will determine the mechanisms of his financial destruction, but will not alter the outcome. The countdown is not to whether Trump loses his empire, but to when and how. The clock is running, the deadline is fixed. The consequences are certain. This is not political theater. This is judicial enforcement. The court has spoken. The timeline has been established. And nothing Trump can do in the remaining days will stop the countdown from reaching zero. The legal countdown has begun. The critical court move has eliminated all escape routes. And when the clock reaches zero on March 21st, Donald Trump's control over his financial affairs ends permanently. The only question that remains is whether he will surrender that control through disclosure or whether he will have it seized through judicial force. Either way, the countdown concludes with the same result: total asset liquidation, complete financial exposure, and the final confirmation that no amount of power, no amount of political office, and no amount of public bluster can override a court order when the judiciary decides that the time for patience has expired and the time for enforcement has arrived.